Lead counsel for the Electoral Commission, Justin Amenuvo, had already indicated to the court that he will be making a request that the Electoral Commission chairperson is given the leeway not to enter the witness box to be cross-examined by lawyers for the petitioner. And he did justify that in his own view by insisting that the settled case law points to the fact that the Electoral Commission chairperson and any witness for that matter cannot be compelled to give evidence in any case.
Also, it's my submission that Rule 3E, all the provisions are quite very clear, and my learned friends putting one interpretation on it on one day and another interpretation on it on another day is most unfortunate. Respectfully submitted.
Mr. Kotompa, who represents President Akufo-Addo's team, agreed with this view and advanced arguments to back the view on why they also have the right not to call Peter McMenu into the box to be cross-examined.
Society of Lloyds versus Sir William Otho Jeffrey BT 2000 EWHC Commercial 51, where the issue of a party failing or refusing to give evidence after a witness statement had been served on other parties in the suit arose, and a prayer was made for the witness to be compelled to enter the box. The court held as follows: where a party, after serving a statement of its witness on the opposing party in accordance with pre-trial directions, decided not to call that witness to give evidence, the court had no power to order that party to call its witness to give evidence in court. Unquote.
Lead counsel for President Mahama Chachuchikata, however, disagreed.
Shall call is mandatory, the last time I checked in the law books. And my lords, I'm sorry.
Lie, as you read.
Yes, but my lords, as that now, nobody has said we don't intend to rely on the witness statement. Nowhere has it been stated. All they have said is that we are not doing. My lord, that is the reality. I mean, however much grumbling goes on the other side, my lord, this is important because there are many options open to us. If they say they are not relying on the witness, we can apply to the court for a subpoena to call the chairperson. For instance, we can apply to the court. Yes, because
I thought it is implied.
My lord, the only reason why we did not take that course is, of course, because she is acting on behalf of the first respondent.
The court adjourned proceedings to Thursday to deliver its ruling. The two legal teams disagree on the quality of the arguments that have been advanced by their respective sides.
It's curious that the petitioner, on whom the burden of proof lies, wants the Electoral Commissioner to mount the witness box in order for him to use the Electoral Commissioner to prove its case. This is not heard of, and our application today was firmly grounded in law. Lawyers, when we go to court, decide the strategy we want to take. We, as counsel for the second respondent, decided to take this course of action.
There is evidence on record showing that she had elected to give evidence and to be cross-examined on the witness statement that she has filed. Now, we will not go into the merits or demerits of what she has filed because the court is yet to give its ruling on that on Thursday. But suffice it to say that the reason why we are insisting that she be allowed to testify is simply because, my brothers and sisters, this is not a debt collection case. We are not here dealing with a private matter, the private interests of private litigants. We are here dealing with the public interest. We are here dealing with the declaration of the results that reflected or is supposed to have reflected the sovereign will of the people of this country.
On Thursday, the issue for determination will be whether or not an individual who has filed a witness statement and indicated to the court that he intends to testify can change his or her mind and decide not to testify any longer and be subjected to cross-examination. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.
Okay, so what would the decision be? 9:30 a.m. the court will sit and they would give their decision. Well, let's have a conversation. Joining me via Zoom for this on the back of Joseph Akable's court reports. Mr. Martin Pebbles joining us. He's a lawyer. He joins us via phone. A very good morning to you, sir, if you can hear me. Hello, Mr. Pebble.
Hi, I can hear you.
Okay, great. Thank you for your time. Dr. Pokoe is also a lawyer. He's part of the NPP's communications team. Good morning to you, sir, if you can hear me. Okay, so do we have Kojoga Daudu then also joining us? Okay, all right. Mr. Pebble, I am with you on this. So all eyes on the Supreme Court. I was just trying to count the rulings so far in this particular petition. And if I may, but even before I go there, the hurdle really is what the rules says, that you cannot force a witness to give testimony. Is that the hurdle that we're crossing?
That is correct. But implicit, or let's say very closely related to that hurdle now, is that even though you can't compel a witness, you can subsequently apply for a subpoena. So where it's very clear, and see the last time, Taki mentioned it during his submission to the court, where it is very clear that in the event that you are not compelling the witness.
Mr. Pebble, please, can you just reposition yourself? I keep losing you.
Hello?
Yes, it's better.
Yes. Okay, so there are two very interrelated principles here at play. You can't compel the witness to come and give evidence. Okay, that is when, so if he wants, he comes. If he doesn't want, he won't. But there is also another tool in the toolbox, which is that a witness or a person can be subpoenaed. So where it is very clear that the person who stands to do, if the witness is not compelled, will apply for a subpoena, then it becomes very difficult to say what will happen. Because, yes, on the face of it, and also plainly on the face of it, you can't compel the witness. But there is also instances in which you can compel when you apply for a subpoena. So you see so what is happening is that, let's say in the context of this case, Madame de Mensa can only say, look, I'm not testifying anymore, okay, because this is actually the issue that's saying to not testify anymore. It's not Madame de Mensa. So physically, we know that it's Madame de Mensa who was going to testify for the EC, because the EC is not a human being. So the EC says, I'm not testifying. But in law, Mr. Mahama has the option to nonetheless apply for a subpoena. As to whether the court will grant a subpoena or not, I don't know. The constitutions and all those, I don't know. We are only doing the analysis. So the court, that tool is available and is hanging very hanging in the air, very close by. Really, it will make the process very interesting to watch. Because if the court were simply to apply this rule, well, the witness cannot be compelled. Finish. Then as soon as they leave court, don't be surprised that you will go and apply for a subpoena. Yes, there are certain things they have to do as part of applying for the subpoena, but we leave that so that it doesn't become a long point. But I'm sure when we use the phrase apply for a subpoena, viewers and listeners understand that. But the hurdles you have to cross to get that, we'll leave that out for now.
So is this vague? I mean, is there something that the court needs to interpret in this decision that we're expecting today? Or is simply what the law says?
It's a combination of the two. Because as I mentioned earlier, if it were just simply what the law says, it's very clear. You can't compel the witness. But in the context of this case, because number one, we've lost so much time. You see, today it's day 11. Today is Thursday, 11th, right? So it means how many days? I'm trying to calculate the days. 11 plus 31 in January. Is that 40? And then the 1 day in December. So today is the 43rd day since the petition started. So we all know that the CI says the case should be handled within 42 days. Today is the 43rd day. So the point I'm making is that because we are hard pressed for time, you see, anything can happen because the court haven't observed the submissions and all this. I'm sure it's not much on them that if they were to just simply throw out his request that Madame Zimensa should mount the box on the leg, he may, in all likelihood, also come back again that, okay, then I want to not to bring her in. So because the court is very much alive to that option that is a Tikata may exercise, it's possible for the court to go down the middle of the road and say, well, okay, so the witness cannot be compelled, but maybe in the circumstances of this case, they will, order. Otherwise, then the court will just, okay, we will not order the witness to come. Then we will see what Mr. Chikata will do about his request for subpoena.
Have we been faced with this kind of situation before?
Not that I can remember, because in 2012, Dr. Afarijan mounted the box. There wasn't much count there about it. In actual fact, Afarijan told me, if you study the record, the person who signed the affidavit at the time, it was being filed. So in this case, let's call it the equivalent of the witness statement. At that time, the person who signed was Mr. Ahmad Sule. I think he was the deputy commissioner in charge of probation or something. So Ahmad Sule, yes, he signed the affidavit. But when it came to mounting the box, it was Dr. Afarijan who mounted the box. That's a part. I don't remember any fanfare about Afarijan mounting or not mounting the box.
And Mr. Pebble, so if this issue is decided, we know it could go either the petitioner's way or the second respondent's way. It hasn't been so much the first respondent, I beg your pardon. It hasn't been so much about the second respondent's witness. If the decision is made today and it goes in favor of the first respondent, what would it mean? Because they say they've closed their case and that the court could make a decision based on what is before it. Would we see a judgment then, a final decision on this matter of the election petition?
Good. So as I mentioned earlier, if it goes in favor of first respondent, that is to say the issue, and that is to say if the court says no, we are not making any order for Madame Zimensa to come and mount the board. Yes, then it means that theoretically, the next point is that the court would ask the lawyers to file written addresses. That they should put together their summary of the case and also all the legal submissions they want to make all together in one document. So it's a written submission sometimes they say written addresses, whichever one. The main thing for us is that we will have to write to the court, and usually, in writing together, where they strengthen their case with the evidence that was given, what's left, and so that matters. Okay? And then the court would adjourn also so the adjournment they will adjourn and say, okay, file by this and this date. You to file by that and that date. Then the court can choose to come and sit on that date for seek clarification. You see? So when you file your written addressing submission or statement of case, the court can say, okay, we are just a certain date for you to come and address us on very serious points. And it usually helps a lot because these submissions or writers take hundreds of pages. And so usually the court will say, okay, come and address us. What you consider out of over 100 pages? We are giving you 20 minutes. Give us your highlights. It helps the court itself, you see, because we have different writing skills. We have different ways of communicating. So after it's written on paper, when you come and you physically stand up more, even if you are using the same word, we get the non-verbal aspects of your communication, the gestures and everything. So it adds meaning to what is written on paper. Okay? Yes. So the court will do it, or the court will simply say, okay, file them. And then the court will simply say, we'll come back on a certain date for the judgment. All of these are possible. But the other side of your question is that let's not lose sight of a very critical aspect of this case. Even if the court were to say Madame Jimensa should not come into the box, a very huge cloud has been drawn around it for not coming to testify. You see, the NDCs will say accountability. This word, let's understand it well. Accountability is no only in Parliament. In law, the court says that is accountability. It just simply means you've been said to have done something wrong. So come to court and answer. Then the judge will hear and determine whether yes, you've done something wrong or not. So the court cases, the millions of them, that is accountability in practice. So please, let's make this very clear. Very, very clear. Please, accountability is not limited to Parliament. Mamavi, tomorrow, if you were called before a disciplinary committee in your workplace, that is accountability. If a query is issued to you to answer for something you have done or not done, that is accountability. So it just simply means calling a duty bearer to answer for something he has done. Maybe in the answer, you will find out nothing wrong was done. That is the process of answering, because it appears that something was done wrongly or was not done at all. That's accountability.
Okay.
So the point I'm making, let me just land on it, that by answering, or not answering, now a huge crowd is involved. And remember, the thing that is about is gathering momentum for the next election. And that's a huge part of this whole case, whether it is spoken or not spoken. Gathering momentum for the next election is what this case is also partly about.
Okay, Mr. Martin Pebu, stay with me. I want us to explore the subpoena angle a bit. But I want to welcome into the conversation Mr. Kojoga Adawudu, who is a lawyer and a member of the petitioner's legal team. Mr. Adawudu, good morning. Also, good morning to Dr. Pokoe Edusei, who is also a lawyer and a member of the NPP's communication team. Good morning to you, gentlemen.
Good morning to your cherished viewers.
Okay. Dr. Pokoe Edusei, can you hear me, please? Okay, great. Dr. Pokoe Edusei, let me start with you on this. You've taken a big risk to close your case. You've chosen not to put your witness in the box to be cross-examined and to give testimony in your favor. There must be something that you probably, the team is aware of that all of us are not aware of. This is huge if it doesn't go in your favor.
Well,
Well, for the issue of whether or not to call a witness, if it goes in our favor, it means that we are bringing to a close, more or less, the entire case. And if it doesn't go in our favor, it means that we will still put the witness in the box. And mind you, for the second respondent, it is not that we need to put our witness in the box by all means, because we actually didn't conduct the elections generally. Just that we were a party, a player in it, and from the figures that we got, we are optimistic that we got more than 50% of the valid votes cast. All that we were expecting the petitioners to do was to also bring their evidence in, and then if there was a need for us to counter them, then we would have done so. But they failed to do that, and we felt that at that point there is nothing to compare again than for us to rely on whatever has been given by the Electoral Commission, and it's actually the correct numbers that have been given by them.
Mr. Kojoka Daudu, this is a huge bridge where we've gotten to, and many people say that you have a difficult job to do. And the decision today, some have written opinions and concluded already. But I just wanted to remind you, all the decisions so far in this particular case has been unanimous. Apart from the court granting you that opportunity to amend, to amend the petition, with those minor corrections that you made, minor mistakes leading to the amendments. All the other rulings have been against you. The interrogatories, the review, it was all the judges. With the review, it was a 9-0 decision. So how confident are you going into today, especially when everybody agrees, almost everybody agrees that this is a difficult one for the petitioner? How confident is your team?
Mamavi, I think that we are confident. Listen, in as much as we are trained lawyers, when you go to court and there is a ruling against you, it doesn't mean that all is lost. It means that the exposition of the law you have espoused is that they say they disagree with you. But Mamavi, is it not interesting that if the whole legal team sits down, look at the law, the interpretation we put to it, we come and the whole Supreme Court not even or see the reasoning of what we are espousing, and there's another ground, it doesn't mean that necessarily we are wrong. It does not mean so. And every lawyer, every person, you know that courts makes decision. When they make decision, at another time, that becomes the law. So it is not that maybe the present time, the circumstances they were saying, that is what. If you look at the interrogatories, the court itself admitted and said that, look, it can be done in cross-examination. So if you don't do it now, we can do it in cross-examination. And that's the more reason why, if they themselves have admitted and see that it can be done in cross-examination, and now it is time for cross-examination, you say, I won't give evidence so that I'll be asked those questions, which the court itself said it can be done. That is one point. So it tells you that it's not necessarily that they have, because they ruled against us, they did not see, and the request to inspect the documents also, it is the same that they said, that it doesn't necessarily mean that you don't have the document, you have the duplicate. So you can always use what you have. So these are different ways by which we have espoused the law and the court has disagreed with us. It doesn't really affect our matter. If it had affected our matter, I believe the court would have even said there is no cause of action. But because the constitutionality of the declaration, that is why the court would tolerate us and know that we always invoke their jurisdiction by the rules. Now, if what will happen today, it means that, like my friend Martin Kwebu has said, there are other ways. The law gives us the rules, and the law we apply give us other options, what we can do. And there are also consequences as to So whether it is ruled in our favor or against, there are other options we can exercise.
Yeah.
And we believe that when it is done, those other options will be invoked.
Let's look at the options that you talk about.
No, I think whilst the lead counsel, Mr. Chachichikata, was talking or was making his submission before the court, he says that there's an option of subpoenaing the returning officer because at the heart of all this, the petition is that you did not do your work well. And the work that you did was lack of transparency, and that culminates in the declaration. And once the declaration was made, an instrument, constitutional instrument, was made to declare the second respondent as president. So it is to call you to answer. Now you answer your question. So there's another way that we can go by subpoena. There's other, and I will leave that after the ruling. I think that the legal team will sit down and look at the law, the rules, what options it gives us,
okay,
and we'll be able to exercise those rights.
Okay.
Now, the issue for the ruling, it's not about the witness statement being an evidence or not. The witness statement, everybody knows as a lawyer that if you file the witness statement, until it is admitted by the court, that's when it becomes evidence. What we are saying is that even the courts at the point allow the respondents to use their witness statement where they have attached exhibits to cross-examine the first and second witness when it was not an evidence, and that point was raised. And the court said they will look at its admissibility and the relevance of that document, that it can be used when the witness statement has not been admitted. Now, when you have used that your documents and exhibits to cross-examine, now you come and say that, no, it is not evidence. So why was exhibits attached to what is not evidence used? It tells you, it exposes the lapses that we are using with our rules introduction of witness statement. So I believe that all we are asking is that if it's a constitutional duty that has been imposed, you have filed your answer, you have made election, by your conduct, it is clear that you have made the election that you would testify. And it is in your affidavit, it is in your answer, you have made the court aware by their conduct. That is what we are saying. So it is about election, but it's not about the witness statement being other evidence or it's not evidence. Because I think it is right. Every person, lawyer understands that if it is not admitted, it is not evidence.
Okay, let's explore the other matter. Mr. Pebble, the subpoena that you first suggested, and which Kojoga Daudu also says it's also an option open to them, depending on how the case is decided today. What form would this appear? How would it happen?
It's the case that Mr. Chikata will mount an application. That is to say, they will apply to the court.
Apologies there. I think we've lost one of our guests. Is it Martin Pebble that we just lost? Okay.
Hello?
Yes, Mr. Pebble. Yes, Mr. Pebble, I can hear you. Go on, please.
So, meaning he will bring an application to the court that he wants permission to serve Mrs. Jean Mensah with a subpoena so that she will come to court to testify. Let's come to the basics. The subpoena is a document that is issued by the court, okay? That's to say, of course, the lawyer presents it and then the court has to admit it. So when the Supreme Court gives permission that he should go and file it, and once he files it in court, he will go and serve a copy of Madame Jean Mensah. And once she's served, she has to come to court.
So in this case, Mr. Pebble, sorry, are we serving the Electoral Commission, or we're serving the returning officer in the 2020 presidential elections, or the chairperson of the Electoral Commission?
In this particular case, so sometimes it varies, but in this case, it means that straight away it will be directed at Madam Jean Mensah.
Okay, please go ahead.
Yes. So once it's served, that one, she has to come to court. She no longer will have an option, because for a subpoena, if the person refuses to attend, that person can be arrested. That's the law. So that one is compulsory. That is why I first said it appears in this case, in order not to, muddy the waters, it's possible for the court to say, look, okay, Madam Mensah, yes, we are aware you have the right to refuse to appear, but also because of the likely events that may unfold, that is to say, application for subpoena and all this, which will lead to loss of critical time at this juncture, we may just choose to say, okay, come in now and just testify to make it short.
What would be the legal grounds for that?
The legal grounds are that, one, the rules are interpreted to achieve speedy, and effective justice. You say, and efficiency. So all the rules of court you find, there is usually a beginning part which will tell you that these rules should be interpreted to ensure that we achieve speedy and effective justice and efficiency in the administration of justice. Do you remember in the 2016, the one Papa Kwesindum, yes, took the EC to court. Yes, so you see that at that time, because of the disqualifications, they sought to disqualify him, right? So when that case went to court, even though the other contestants had not yet come to court, the Supreme Court looked at it and said, look, even though other persons have not come, in order not to lose time, we will order that the EC should give everybody an opportunity to rectify. I think there were some mistakes in the filling of the forms. You remember?
Yes.
So the point I'm making is that it was Indum who was before the court. He had not yet, the others had not come. Nana Kunedu was battling hers, and then there were other contestants who were also, railing about the EC being unfair to them, Yes. So the Supreme Court looked at the circumstances on the ground and said, look, even though we have only Indum here before us, we are making an order that all the other cases which are likely to come to the Supreme Court, in case the people are not happy, look, EC, just give all of those people an opportunity. So the Supreme Court abated several cases coming before it, so that each contestant will bring his case. Each contestant brings his case, then we lose time. So the court has shown there are other examples in our history.
So yeah, Mr. Pebble, this one is clear. How about the grounds for the subpoena in this particular matter?
Yes, so I remember that one too. We mentioned, I said for the grounds, we cannot speculate at this juncture, but the ones that will be clear are what Mr. Adaudu referred to. You see, that critical affidavit, in which Madam Jean Mensah said, that's the affidavit in response to the review application about when the Supreme Court threw out the interrogatories. Madam Jean Mensah's affidavit says that, Mr. Chikata shouldn't worry. He can ask his questions in cross-examination, meaning she was going to mount the box. You see, so that document is extremely critical, and also to a smaller extent, the fact that Madam Jean Mensah put in a witness statement. As you stated, on the law, she's not compelled, she cannot be compelled to come into the box. But at least by filing it, it has given some indication that she would come. You see?
Okay. I'm just curious a bit. How about the fact that when 2 justices were added for the review, there was one of them who said to Mr. Chikata that you could ask these questions after all during cross-examination. Would that also count?
Excellent. Mamavi, well, you are a lawyer already. That's it. So add on. Yes, add on. That's correct.
Okay. All right, Mr. Pebble, we'll leave it here. Hopefully we can talk to you during our updates just before 9:30. I hope you won't be chasing butter and bread then. But let me come to Dr. Pokoe Dusay on this matter. We've explored the other angles. These are possibilities that I'm sure your team must have also looked at, right?
Yes, we have. You know, last week when the court, in fact, it was this week, when the court sat on Monday, Mr. Kutuampa, the lead lawyer for the second respondent, gave intimations as to what our stance could even be, that the petitioner has closed his case. So you also advanced argument. That's why it won't serve the ends of justice if even in the unlikely event of subpoena applications coming in. So those will be attended to. But just a quick response to the submissions of my other colleagues. You know, sometimes we over-elaborate on the interrogatories, those 12 questions, so much as if they are cast in stone, as if that is actually what will change and give the petitioner sufficient evidence to succeed in this petition. You know, you asked the question, was NCA involved in transmission of election results? I mean, NCA was never involved in transmission of election results. So these kinds of questions... Yeah,
but you are not the Electoral Commission. Wouldn't it be good if the Electoral Commission answered that?
So it's a question which is even at large, and it won't elicit any evidence that will aid their case in any way. So they should not bang their hopes so much on the those 12 questions, as if it is a question which is like the Ark of the Covenant, that as soon as you bring it, all your enemies will scatter, and the entire thing will inure in your favor. It doesn't work that way. When they were coming, they had every opportunity to put in all the witnesses, to put in information in terms of the pink sheet they had in the 38,611 polling stations, and plus the social voting of, I think, 311 or so polling stations. They had all those evidence. So if these pink sheets have been brought, or indications of them as to what is contained on each has been brought, it will just be about tallying to know whether Mr. Mahama got 48.9, and therefore the president didn't get 50 plus 1 vote. I mean, it would have been so straightforward for everybody. But it is the paucity of evidence that they have submitted. That is where the challenge is. So if you have failed to meet your persuasion requirement, the burden on you, as required under Section 14 and 17 of the Evidence Act, it means that there is also a challenge in calling the other person to come and respond, so that you will then develop your case through the case of the other person. That is where we have that challenge. So we have our strategy in place. I've already said it, and we will advance it in due course. So let's not rely so much on those 12 questions as if we can change the outcome of the entire case of the petitioner.
Okay. Ms. Adaudu?
Yes, Mamavi, I believe that what will happen in court today will determine what will be the next line of action, what we should be doing. But then I think that, let me make one important point, that if you look at the relief that we are seeking from the court, we have not asked that based on the figures that we got from the declaration or electoral commission, rather the petitioner should be declared validly elected. This is what happened, the relief they put in the 2013 petition. So that is why they are getting it a little bit confused that we should have brought figures. If we had asked for that relief, that based on the figures, it is the petitioner who has won and he should be declared validly elected, that is when the issue of figures should be coming. At the heart of our case is that the declaration and the process violates Article 63.3. I can assure everybody that the lawyers are working for the petitioner, and at the end of the day, whatever the Supreme Court decides today, we have other consequences. We have other actions that will kick in. And I think that the subpoena was one of the actions that has been discussed. I'm sure there are other options that will kick in, and will make sure that the interest of justice is served. As Martin said it is speedy trial, effective justice, and the court has always spoken that the rules should be interpreted based on the rules, the speedy. That was why at the point they said we will not apply some rule because we want speedy trial. So it's all entirely in the hands of the Supreme Court to decide what they want to decide today, to make the law and back it, give us reason and well-researched reasons why they will not allow. And from there, we would move on.
Okay. Well, Mr. Daudu, as I say all the time, I wish you well in court today. Dr. Pokoe, I wish your team same in court today. We will be watching. We'll be counting down to 9:30, certainly be following through with this crucial ruling from the court. Mr. Kojoka Daudu is a lawyer,
It's a great pleasure talking to you, Mamavi.
Great, thank you. He's a lawyer and a member of Mr. Mahama's legal team in court on this 2020 petition. We also had Dr. Pokoe, also a lawyer, member of the NPP's communications team. And Mr. Martin Pebble also joined us. He is a lawyer as well. Today, we have a Healthy Thursday conversation, and we have an immunologist joining us to answer your most critical questions. There are still lots of questions about the schools recording cases, people not opening up some schools, keeping the fact that they've recorded cases to themselves, which means that other parents may not necessarily know, and their children may not get tested. So there are lots of questions on our minds. Also, the issue of the South Africa, the challenge that they're facing with the vaccine and how they are abandoning that. Meanwhile, we are aiming to get those same vaccines. So if you've got questions bothering you on all of these, join our next conversation. Stay with us.